Hi guys, this is part 3 of our sessions on fundamental rights. I hope you understood the first two fundamental rights in our first two sessions. In this session, we will discuss the other four fundamental rights which are enshrined in the Constitution of India. So the fundamental rights that we discussed today are not as widely interpreted as the other rights that we discussed in the first two sessions, but they're really important to understand because these are the basic rights for every citizen in a country, and in India these are regarded as fundamental rights under part 3 of the Constitution. So the first right that we discussed today is right against exploitation. So right against exploitation is given in Article 23 and Article 24 of the Constitution. It states that any form of forced labor, begar means labor without any wages, or human trafficking. Trafficking means selling of human beings for commercial or for sexual purposes. So that is completely prohibited within the territory of India. So Article 23 basically prohibits certain activities like slavery, forced labor and so on. So these were certain practices which were prevalent during the British era and sometime after that as well. This is prohibited now. So Article 24 now talks about child labor. Child labor is another huge problem that our country is faced with. However, it is punishable and it is protected under the fundamental rights of the Constitution. So Article 24 states that any practice of child labor is prohibited, and the fundamental right defines child labor as any person or any child below the age of 14 years who is involved in any hazardous factories or any hazardous activities is prohibited. Now there was this act called the Child Labor Prohibition and Regulation Act of 1986. It had certain criteria as to what is child labor and what should be done and how will the people who's involving in it will be punishable. Now there was this amendment to this act in 2016. The name of the act has been extended and the scope is basically widened, and it is named as the Child Labor and Adolescent Prohibition and Regulation Act of 1986. In the 2016 amendment, the definition of child labor has also been changed. It means that any child below the 14 years of age who has been involved in any factory or any business for that matter is a punishable offense. So no child below the age of 14 years can be put to work. Or this does not include working in a film or working for a home enterprise. It does not include those. These are certain exceptions, but other than that, any child under the age of 14 years working anywhere is a punishable offense. And from age group 14 to 18, involvement in any hazardous activities, for example, cracker factory, in mines, that is not allowed. So the adolescents, that is from age 14 to 18, are not allowed in hazardous activities. That is what Article 24 says now. Not the Article 24, but the new amendment in 2016 that came forth. Now we discuss another important fundamental right which is enshrined in the Constitution, which is right to freedom of religion. It is mentioned in Article 25 to 29 of the Indian Constitution. So religion is really important because it's based on beliefs and we are really strict about our religious beliefs. Every community, every religion has certain customs, traditions, and we are really strict about it and we do not deviate from it. However, this article or this particular part of the Constitution, which is right to freedom of religion, makes our country secular. We do not have a state religion. We might have a majority and minority, but we do not have a state religion. We do not have a state language. We are a secular country. We promote and we respect each and every religion. So there are four basic fundamental rights that are mentioned with respect to the religion in India. So it states that everyone in India is at a freedom to freely propagate, profess and practice any religion. So you can talk about your religion, you can propagate it, you can practice it. Basically, you can do whatever that religion asks you to do. And there are certain restrictions that can be imposed on that religion in the interest of public order, health or morality. So one of the most prevalent and the most important questions that is asked in CLAT and in other competitive exams with respect to this article is what are the essential practices of a particular religion. So you will be given a fact, say for example, government passes a legislation जिसकी वजह से लाउड स्पीकर्स बैन हो गए in mosques or in certain other places which were used for religious purposes. Now, loudspeaker, as it had been held, is not an essential practice for any religion. Be it Muslims, be it Hindu, there is no essential practice of using loudspeakers in any religion. So that can be restricted in the interest of morality, public order, and health. I have attached a list of the practices that are not so essential and that are essential for a particular religion in the description. You can go and have a look. Now, the next article, which is Article 26 of the Constitution, states that every religious denomination can actually establish and manage religious organizations or charitable organizations which are religion based. And for that purposes, they can also acquire immovable and movable properties, and they are allowed to do so. So that is the second right which the Constitution provides us with respect to freedom of religion. The third right that the Constitution provides us with freedom of religion is that every person in India has the right to not pay any taxes or fees which are levied by a particular religion or a particular religious sect. So we are at a liberty to not pay any such taxes or any fee that is levied on the basis of religion. Now, the last freedom that is given to us with respect to freedom of religion is that we are at a liberty to not be involved in any religious instructions that is given in any institution which is fully funded by the state. So अगर सरकार का पैसा आता है किसी भी ऐसे इंस्टीट्यूशन में जो कि फुली फंडेड है सरकार के पैसे से, so there cannot be any religious instructions in those institutions because we consider each and every religion as equal. So we cannot have a particular religion dictating that particular institution. So these are the most important fundamental right that is mentioned under Article 25 to 29 of the Constitution with respect to right of freedom of religion. Now the third fundamental right that we discuss for today is cultural and educational rights. These are mentioned in Article 29 and 30 of the Constitution. So we know that India is one of the most diverse countries in the world. There are not many countries who has more languages, more customs, more traditions and so on, and India is actually very popular for its rich heritage. But that creates some sort of a problem wherein some language or some culture might be in minority and may not be very important for majority of the population. But Article 29 and 30 provides that such religion and such language can be preserved by people who wish to do so. So any religion or any culture, any language that is even in minority, say even 100 people speak those language, they have the right, they have the fundamental right to protect and conserve that language or that culture. Article 30 talks about that there can be certain religious institutions which can be maintained by certain religious organizations or certain religion also. So we see that there are certain madrasas in which people go and Muslims generally go and they are taught there. So this is actually enshrined under Article 30 of the Constitution, and minority have these rights to do so. Although the state cannot discriminate between these organizations on the basis of religion or caste or creed for that purpose. So this is about Article 29 and 30 of the Constitution. We discussed earlier that Article 31 was omitted from the list of fundamental rights, so we no more have Article 31, which was right to property. It's a constitutional right now. Now the last provision that we discussed for today is Article 32 of the Constitution. Now we discussed 5 fundamental rights so far. Now none of the fundamental rights will make sense unless we have a recourse to go somewhere if these fundamental rights are violated. अगर ये fundamental right का violation हुआ तो हम क्या करेंगे? That is given in Article 32 of the Constitution. So Article 32 of the Constitution was called the heart and soul of the Indian Constitution by Bhimrao Ambedkar. So Article 32 states that we can move to the Supreme Court of India under Article 32 if any of our fundamental rights are violated under the Constitution. So under Article 32, the Supreme Court is given power to issue 5 writs. Now, what are these writs are important to understand. We just need to understand the basics of it. So the first writ is the writ of habeas corpus. Habeas corpus literally means to have a body. So this writ is basically issued when there is some sort of an illegal detention or illegal arrest of a person. So we studied in the second lecture that we cannot keep a person in custody for more than 24 hours. If that is done and a fundamental right violation suit is filed in the Supreme Court, the Supreme Court has all the right to issue a writ of habeas corpus. So the second writ that we talk about is the writ of mandamus. It literally means to command. So Supreme Court issues this writ when it feels that certain government officer or public officer is doing something illegal or is perpetrating an act which is illegal. It is also issued when certain public officers are not fulfilling their duty, basically omitting to do so, then also a writ of mandamus can be issued. So there is another writ which is issued by the Supreme Court which is called the writ of prohibition. Prohibition, as the name suggests, means to prohibit. So if there is any court, any inferior court or tribunal which passes any order which is arbitrary or which is against the principles of natural justice. Natural justice means basic principles of law. For example, one of the principles is audi alteram partem, which means hear the other side. So a court cannot pass a decision by hearing only one side. If such arbitrary decisions are made by the court, then a writ of prohibition can be issued by the Supreme Court. It basically means stay order that we generally discuss in layman language. Now, the fourth writ that we discuss about is the writ of quo warranto. Quo warranto means by what warrant or by what authority. So when a public officer holds a public office without any authority. So illegally अगर कोई public office को hold करता है and that person is not entitled to do so, then a writ of quo warranto can be issued by the Supreme Court of India. Now the last writ that we discuss about is the writ of certiorari. Certiorari means to certify. So this writ is issued when an inferior court or an inferior tribunal passes certain orders or gives certain judgments which are not within their jurisdiction. Jurisdiction क्या होता है? So every court work within a particular jurisdiction. Okay. So for example, the High Court of Rajasthan passes a judgment for an activity that happened in Tamil Nadu and it has got nothing to do with Rajasthan. Then such a decision cannot sustain in a court of law because that the court does not have the requisite jurisdiction. Jurisdiction का मतलब होता है it does not have the power to pass such an order or such a decision. So that is what jurisdiction means. So if it is done without jurisdiction, then a writ of certiorari can be passed. Other than Article 32, writs can also be passed by various high courts under Article 226 of the Constitution of India. I hope you understood our sessions on fundamental rights and it gave you a basic clarity as to what are fundamental rights from the examination point of view as well. If there are any doubts, you can always mention it in the comment section. You can also write to us on our mail ID which is given in the description box. If you like our sessions, please subscribe to our channel and press the bell icon so that you don't miss any updates from us. Thank you.